Cool. Should be on. All right. As I said earlier, we went out on the street and talked to some people about the Bill of Rights. And basically we're concentrating on the first 10 amendments to get an idea of the public awareness of the constitutional rights. And we received some interesting answers. And I'd like to ask you a few questions about the Bill of Rights as a professor of political science for the last 20 years. To help us with a deeper understanding of from the intellectual viewpoint. The first question that we asked our people on the street was, what was the Bill of Rights? And Dr. Manning, how would you respond to that?
Well, the Bill of Rights were passed in the aftermath of the Constitutional Convention. At the Constitutional Convention, the Federalists, or people who came to be, referred to as the Federalists, created, what eventually became the Constitution, which involved the creation of a much, much stronger federal government than that which existed under the Articles of Confederation. Now, in order to assuage the fears of people who thought this new federal government would be too strong, the Bill of Rights was created and passed pretty much at the same time as the Constitution. And I think most scholars would agree that the Bill of Rights were instrumental to the passage of the Constitution. Without the implicit promise of this Bill of Rights, there perhaps would not have been a Constitution.
That actually leads into our second question. We had some interesting answers to the next question, which was, why was the Bill of Rights written? And I was looking for two answers, basically, which I happen to agree with, which are, they were written in order to ratify the Constitution. And as you said, I think you agree.
Sure.
And the Bill of Rights purpose is the same as the Constitution, and that's to limit government.
Well, the Constitution itself represents a massive expansion of federal power compared to the Articles of Confederation. And everybody knows that, everybody knew that. And that's why the Bill of Rights was important, to take this potentially much, much, much stronger federal government and build in checks on it. Mm-hmm. As I said, to assuage the fears of those people who would be known as the Anti-Federalists. The Anti-Federalists would be people who just did not want to see the Constitution passed. And at least enough of them were mollified by the Bill of Rights that the resistance to the passage of the Constitution was lessened, and it was passed.
Would you agree with that reasoning of the time?
Yes.
Do you think it's still valid today?
Yes. But what's interesting in the history of constitutional law is that the Bill of Rights have been used primarily as a vehicle to further expand people's rights, especially through the 14th Amendment, due process and equal protection clauses. For example, under a whole series of cases, a right to privacy has been developed, encompassing areas such as ability to use contraception, Roe versus Wade, right to privacy that includes abortion with certain restrictions, and also Morris versus Texas in 2003, the right to private homosexual conduct. None of these things are guaranteed in the Constitution, neither are they explicitly forbidden. But as a result of constitutional interpretation, this, what I would say is a pretty generous, liberal right to privacy has been created out of the Bill of Rights, which I would say is a very valuable thing.
Through presidential law, then?
No, it's not presidential law, but through Supreme Court decisions.
Right. It has been said that our founding fathers wrote the Constitution to govern human nature, and that they understood the natural inclination of rulers to want more power. How would you respond to that?
That's true. Yeah. Most of the amendments begin with "Congress shall make no law," basically resulting in a pretty severe limitation on the powers of Congress. And at the the time they saw Congress as the prime mover of this new government, since it did have the sovereign power of creating laws. And I think it's part of the balancing act the Founding Fathers had to achieve. They wanted to create a much stronger government than that which existed under the Articles of Confederation, because the government under the Articles was just very, very weak. There's a reason the same people who passed the Articles wrote the Constitution, because the one was just not getting the job done in the middle of the 1780s. But there was also the fear, yes, you have to create a much more powerful federal government, but you do want to build in checks, which is one major aspect of our pretty sophisticated and pretty successful system of checks and balances. And I also like, as most people do, how through the 14th Amendment, restrictions on the power of Congress have been applied to the states through the equal protection and due process clauses. Because I really don't think the states should have the right to abridge your freedom of religion or speech any more than Congress. And that process is known historically as selective incorporation. And it's very involved history.
And that's protected from an earlier amendment, right? Concerning the power of the states and the federal government's reach into that.
Well, in the original Bill of Rights, those are only restrictions on the power of Congress. But as a result of the 14th Amendment passed in 1868, one of the post-Civil War amendments, in order to protect the rights of the newly freed slaves, you have the equal protection and due process clauses of the 14th Amendment that apply for the first time to the states, not just the federal government. And then those clauses have been instrumental in bringing the rights enshrined in the first 10th Amendment and making them mandatory onto the states. For example, recently, a decision that a lot of conservatives are very familiar with, the court has more or less for the first time declared the Second Amendment right to firearms, right to bear arms, to be incumbent upon the states, making it very difficult for states and localities to pass gun control legislation for the first time. That's kind of the same principle, selective incorporation through the 14th Amendment. Just a conservative area, because most selective incorporation issues have been the liberal expansion of individual rights. And this is the liberal expansion of gun rights, which is generally seen as a conservative issue.
Right.
It's interesting.
That's definitely a hot button issue.
And that's fairly recent. The court has just moved in that direction, recently.
Good. Well, that's kind of it for me. Anything else you'd like to add?
No.
All right. Thanks for your time.
Okay, thank you. Did you get some interesting